3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hivner. On behalf of Judges Stafford and McBrayer, welcome. And we will conduct this just as if we were all sitting in the courtroom. If there's no questions, Mr. Hivner, would you call the case, please?
In re Estate of Tom Cone, Jr.
Morning, Your Honors. I am Charles Michaels, representing the appellant, Susan Lagone. I am reserving 5 minutes for rebuttal. Miss Lagone was the sister of the decedent, Tom Cone, Jr., and this dispute arises out of Tom Cone, Jr.'s last will and testament, which was executed on May 2nd, 1996. That grants a specific request of any interest that I may own at the time of my death in Cone Solvents Incorporated to Miss Lagone, if she predeceased him, and if not, then and if she did predecease him, then to her father, Tom Cone Sr. There was a residuary clause leaving other assets to his then wife, Cassandra Cone, as well as any children that he may have. Cone Solvents Incorporated was incorporated in 1972, and it was always a chemical sales and distribution business, and the only persons to ever hold an interest in it were Tom Cone Sr., Tom Cone Jr., and Susan Lagone. Specifically, in 2007, decedent owned 12.5% of CSI, as I'm going to refer to it. Susan Lagone owned 12.5%, and Tom Cone Sr. owned 75%. As it's relevant to this case, in July of 2006, decedent began operating a separate entity known as FLS LLC with a man by the name of Don Gadd. Decedent owned 85% of FLS, including 100% of the governance rights of FLS. Its business was always the hauling and trucking of products, and it primarily operated out of the same locations as CSI. In approximately November of 2009, the decedent separated from his wife, Cassandra King, but they never formally divorced, although Miss King admits that the decedent kept his finances and substantial business interests private, which continued through his death on November 6, 2015. Moving back to Cone Solvents, in October of 2010, due in part to potential environmental liabilities that could be assessed against Cone Solvents, FLS purchased all of Cone Solvents' assets and liabilities with the exclusion of CSI's shares, and CSI was dissolved shortly thereafter.
The asset purchase, was that just an assumption of debt and liabilities deal, or was there cash that was paid over to
Yes, I apologize for interrupting. There was a $475,000 cash payment that was made to Tom Cone Sr., as well as an ongoing consulting agreement that paid him $10,000 a month for up to 10 years, regardless of whether he did any actual consulting.
So Cone Solvents received no cash as part of the transaction?
That is correct. Cone Solvents itself did not receive any cash.
So the loans that we're reading about from, I think, Pinnacle, what were the proceeds of those loans used to do?
Some of the proceeds were used to pay debt that belonged to FLS and Tom Cone Jr. that was outstanding, but most of the loans were used to either secure CSI's existing debt or pay down its debt.
Of the cash payment that did go to Cone Solvents, did the shareholders receive any distributions of that cash following? I appreciate that Mr. Cone Sr. got some direct payments as a result of a consulting arrangement, but I'm talking really about as a pass down, either a dividend or a distribution to the shareholders of Cone Solvents.
There were no cash payments to the shareholders of Cone Solvents. Specifically relating to that, as part of the transaction, FLS gave Susan Lagone a 12.5% interest in FLS in exchange for her 12.5% interest in Cone Solvents. So while she didn't receive a cash payment, she received an equivalent interest in FLS.
And when did that transaction occur?
It was substantially around the same time as the asset purchase agreement. It may have been within a week. It was definitely within a month.
If her interest in Cone Solvents was acquired by Mr. Cone Jr., why would she then be signing off on articles of dissolution and articles of termination? Because she's no longer a shareholder.
To clarify, she did not give up her shares in CSI to receive her 12.5% interest in FLS.
So I thought the consideration for that transfer was just $100.
That's correct.
Okay.
Looking at it from a practical from a what occurred perspective, what she actually
Frontier
received.
Frontier Logistics have any business other than the solvent business?
My understanding is they did not, and all of their operations were out of Cone Solvents locations.
So they gave up the logistics component of that business after the asset purchase.
They gave up, referring to who?
I'm trying to determine what business Frontier Logistics had at the time of Mr. Cone Jr.'s death.
At the time of his death, they were in the business of both chemical sales and trucking and distribution. At the time of the asset purchase agreement, they were in the business of trucking and distribution.
Thank you.
All right. Does that answer your question completely? I just want to make sure.
It does.
Okay. Going back to FLS and the interests that were owned after the asset purchase agreement, Tom Cone Jr. owned 85% of FLS prior to the asset purchase agreement. Afterwards, he owned 72.5% because he gave 12.5% to Susan Lagone. Don Gadd remained a 15% owner of FLS both before and after the asset purchase agreement. And then after the asset purchase agreement, the sales of FLS, its total income per year from 2011 to 2015, 87.8% to 94.63% of its total income came from the sales of chemicals, which was the business of CSI, whereas 5.37% to 12.2% of its annual income came from the business of trucking and distribution, which is what FLS did before the asset purchase agreement came into place. And this appeal resulted as a result of the summary judgment granted in favor of Ms. King that decedent didn't have any interest in anything that could be considered Cone Solvents Incorporated in his estate at the time of his death. The trial court specifically ruled that the only interest that anyone can hold in a corporation is the corporation's stock. Looking at the asset purchase agreement and the will itself, the will refers to any interest I may own at my death in Cone Solvents Incorporated, as opposed to my shareholder interest or my corporate shares. Or
counsel, what interest do you think was owned besides the interest in the stock?
he owned an interest in the ongoing business of Cone Solvents Incorporated, to the extent that he continued to hold Cone Solvents Incorporated out as a functioning entity that existed and sold products to customers and essentially functioned as it had before the asset purchase agreement was entered.
But
I
we're
thought it-
we're talking, I'm sorry, go ahead.
I thought CSI terminated by the Secretary of State in a year after, or in September of 2011. So by the time Mr. Cone Jr. passed away, it didn't exist, right?
That's correct. Should I answer your question with my time having run down?
Yes, answer whatever question is left out there.
Yes, it was terminated. He continued to hold it out as existing, and the ramifications of that are as they are under state law.
Judge Stafford, did you have further question?
Well, just one and perhaps a follow-up depending upon the answer. We are talking about a corporation at all times, correct?
At all times, it was a statutory corporation up until the time it was dissolved.
And unless things have changed, isn't the way that you own an interest in the corporation by the stock of the corporation?
It is, unless if you continue holding out a corporation as existing after it is no longer a corporation.
Okay. Thank you.
Thank you very much. It's time for the appellee, please.
Good morning, Your Honors. May it please the court. Michael Hoskins of the Nashville Bar on behalf of petitioner appellee Cassandra Cone. Your Honors, this is a will construction dispute between the decedent's widow and his sister. The decedent's widow filed a petition to construe the will, asserting that the specific bequests lapsed under the doctrine of redemption by extinction. As the court is aware, the court follows a two-part test to determine whether an redemption has occurred. One, whether the gift is a specific bequest, and two, whether it's found in the decedent's estate at the time of his death. As the 1996 will provides, the decedent executed a will leaving his interest in Cone Solvents, Inc., which is a Tennessee corporation, to his sister. At that time, the decedent owned a 12.5% shareholder interest in the corporation. Tennessee courts have consistently held that a share of stock represents its owner's proportional interest in the corporation. Citing the Tennessee Supreme Court opinion in Hinton versus Carney, the trial court held that the thing given was shares of stock, which if the decedent owned any, is the personal property which upon the death of the owner goes to the administrator. That is cited directly from the Supreme Court opinion in Hinton versus Carney. Respondent argues that this ruling is in error, but fails to cite to any authority or identify any other interest in CSI that the decedent could have owned at the time of his death. This assignment is in error and without merit. The dispositive issue before the court is whether or not the specific legacy has been deemed or whether or not it still remains in specie. Construing a will is a question of law for the court, and the court aims to give effect to the actual language of that is used in the will itself. Item 3.2 provides, I give, devise, and bequeath any interest I own at the time of my death in Cone Solvents, Inc. There is no dispute between the parties that 3.2 creates a specific bequest. Therefore, the sole issue is whether or not the decedent owned an ownership interest in Cone Solvents, Inc., a Tennessee corporation, at the time of his death in 2015. The trial court held he did not, because in 2010, CSI sold its assets, dissolved the corporation, and surrendered its charter. And summary judgment was properly granted because the undisputed and stipulated facts is that FLS was not merely the continuation of CSI, but was a separate, ongoing, and viable entity years before it purchased CSI's assets. The undisputed facts demonstrate that, and CSI was founded in 1972 and sold and distributed chemicals. In 2006, the decedent—
Mr. Hoskins, you heard the responses to the questions about the nature of the asset purchase transaction in October 2010. Do you agree with the recital of the facts relative to that? It was all basically an assumption of debt and or primarily an assumption of debt and liabilities, and that maybe a little less than $500,000 went in cash.
Well, I do not agree with that, Your Honor. If we have sealed Exhibit 6, which is the asset purchase agreement itself, and that agreement attaches as one of the appendix to that agreement, Your Honor, it shows where the distribution of the funds went. More than $8 million a loan was raised, and it was personally guaranteed, part of it by the decedent. Over $4 million, $4.5 million was actually paid of debts that were in the name of Cone Solvents exclusively. So the payment of those debts, those $4.5 million, as well as their ongoing payroll obligations, is actual consideration for the assets that were purchased. And what we are asserting here is two separate corporations negotiating at arm's length to purchase those assets. And that's what occurred in this case. And so when the decedent started FLS back in 2006, they were not in the business of selling chemicals. They were, as Mr. Michaels concedes, they were a hauling and trucking company.
They're still doing that to this day, correct?
They are still doing that to this day, Your Honor. And in 2008, the exhibits show that FLS was distributing over $900,000 to the decedent as his annual profits. In 2009, it distributed close to $1 million to the decedent as his share of annual profits. In 2010, FLS reported annual sales of over $18 million. So during this time period, between 2006 and 2010, the decedent held ownership interest in both companies simultaneously. He held a 12.5% shareholder interest in CSI and an 85% membership interest in FLS. Therefore, these facts demonstrate, and all of these facts are undisputed, they were admitted in our statement of undisputed facts, that FLS as a separate legal entity with distinct ownership interests and with a different business model was independently operating and generating millions of dollars of revenue even before it purchased CSI's assets. Consequently, decedent's interest in FLS is not the same or substantially similar to his former interest in CSI. And that distinguishes this case, Your Honor, from the Baldwin versus Davidson opinion and all the other authorities cited by respondent, where there's just been merely a change in the form of the company, whether it be from a partnership to a corporation or from a corporation to personal ownership, and the essential nature of the business stayed the same, or the decedent's interest in the business stayed the same. Here we've got a material alteration, not only in the nature of the business, but also in the decedent's interest in the business. And consequently, this court must find that there has been a material alteration in the subject matter of the bequest, and or that the bequest has been lost and was disposed of during the testator's life, and therefore an redemption has occurred as a matter of law. But the facts are a little more detailed in this case, because the decedent did not sell his membership, he did not sell his shareholder interest in CSI. His membership interest in FLS and his shareholder interest in CSI remained separate and distinct. As the court's aware, corporations and their shareholders are distinct entities, and the assets of the corporation are not the assets of the shareholders in their private and personal right. And when October 7th, 2010, when FLS and CSI entered into the asset purchase agreement, CSI sold substantially all its assets to FLS, but it expressly excluded all of CSI's stock from the transaction. And therefore, all the assets that FLS purchased from CSI were titled in the name of the corporation and therefore were corporate assets and not the assets of the individual shareholders in their private and personal right. And so,
Counsel, let me ask you a question. What, out of curiosity, primarily, why was the stock excluded from the transaction? Do we know that based on any proof in this record?
we do not know why that is, Your Honor, but we do have the agreement itself, which is voluminous and sets forth expressly what assets were being purchased and what assets were being excluded. Not only was the stock excluded, but also the shareholder receivables of Cone Solvents Inc. were excluded. And if Your Honor is aware what shareholder receivables are, shareholders' receivables are loans either to members or shareholders of the company or loans back and forth. And so whatever loans
Had
were
Ms.
made,
Ligon made any loans to Cone Solvents?
their shareholder receivables, no, Your Honor, not that I'm aware of. Ms. Ligon made no loans to there. So, Your Honor, after the sale, there were formal steps taken. It was clearly the manifest intent of the parties to terminate Cone Solvent Inc.'s legal existence. On December 21st, they took formal joint action by written consent to dissolve, liquidate, and terminate CSI's corporate existence. They entered into a plan of liquidation, which was recommended by the directors, approved by the shareholders, and which authorized the corporation's officers to wind up the affairs of the corporation. They subsequently filed articles of dissolution with the Tennessee Secretary of State on December 29th, 2010. And then upon obtaining a tax clearance letter from the Tennessee Department of Revenue on September 20th, 2011, Tom Cone Sr. filed articles of termination of corporate existence of Cone Solvents Inc. with the Tennessee Secretary of State. The Tennessee Supreme Court has held that when a charter is granted, a distinct corporate entity comes into being, and when a charter is completely surrendered, the corporate entity ceases to exist. That's Brinkley versus State. Consequently, when CSI's corporate existence terminated, the decedent's interest in the corporation terminated with it. As a matter of law, decedent's ownership interest in CSI was lost or disposed of prior to his death, and therefore the specific request made to respondent was deemed by extinction, and the summary judgment ruling should be affirmed. Now, Your Honors, respondent has made much of the fact that FLS purchased the Cone Solvents name and its logo and used it as a trade name. Respondent argues that FLS use of the Cone Solvents name and logo leads to the conclusion that somehow CSI is still operating, although unincorporated. And respondent is mistaken. Your Honors, the name of the business is part of the goodwill of the business, and goodwill is a property right which may be bought and sold in connection with the sale of the business. I cite Andrews versus Sprinkle. For that position, Your Honor, it's undisputed that when FLS purchased CSI's assets, it also purchased the name, the website, the logo, and all the copyrights associated therewith. So if it still has some letterhead, or if it's still got the logo on some of its trucks, it does not mean that it does not mean that CSI continues to exist as a legal entity, or that the decedent held a personal property interest that could pass to his estate upon his death. Your Honor, so that's the central crux of what this case is about. The CSI does not exist as a matter of law. There are other issues that were raised on appeal which are not with any merit. The second issue that was raised had to do with Tennessee Code Annotated 32-3-101. As this court, as record will reflect, that code section was never cited in the lower court ever. It wasn't cited in their brief in opposition to the motion for summary judgment. They filed two separate briefs in opposition to the motion for summary judgment. That section of the code was never cited. They filed a motion to amend the summary judgment ruling. That section of the code was never cited. They bring it up for the first time on appeal before this court. And I would cite the court to the transcript of the evidence, transcript of the hearing, which is volume 17, page 13, Your Honor, page 13 and 14, where that code section was never cited before this court. Your Honor, the other issue that Mr. Michaels has raised is the issue about adding evidence to the record. And I would also refer the court to the transcript, volume 17, page 21, line 23 through page 22, line 18. In the lower court, during oral argument, opposing counsel conceded in open court to the judge that he was not attempting to add evidence to the record in order to change the court's summary judgment ruling, but only to provide new evidence for consideration on appeal, which is expressly prohibited as the appellate court is not a trier of fact. The issue, and a litigant is not permitted to file briefs in opposition to summary judgment, conduct whatever discovery they want, and after the summary judgment issue has been resolved, to add a new additional evidence for consideration on appeal that was not considered before the trial court. That was expressly admitted by opposing counsel in volume 17, page 21 through 23, page 22 through 18, line 18, that the issue of the additional evidence was not something that he was asking the court to actually consider in the trial court. And Your Honor, the valuation report, which is regarded the appraisal, it was in, it was not only referenced and attached to the petition to construe the will, but it's cited in over 8 or 9 paragraphs. And therefore, the respondent issued asserting now that they were prejudiced by the trial court's failure to consider that information is without merit and not a basis for reversal of the appeal. And if there's any questions, I'll thank the court for its time. Thank you.
Thank you very much. Mr. Michaels.
Thank you.
Mr. Michaels, could you address the waiver argument first regarding the statute?
Yes, I believe I referenced it in my reply on this appeal, that it was first raised by way of a reference to Lord Thurlow's statement that intent is relevant, and a case citation to Daughtry v. Daughtry before the court or before the trial court, and then it was also addressed.
I guess you would concede then the actual statute wasn't brought up.
It was raised in oral argument on the motion to alter or amend, which at the time wasn't a final order. So it was raised during oral argument before the trial court.
So, but that was the first time the actual statute was mentioned.
I believe that's the first time the actual statute was mentioned, as opposed to just stating intent at the time of death is what is relevant.
Going to your additional evidence argument, what efforts, I mean, it seems like to me that to bolster your argument that somehow Cone Solvent's existence continued even after the termination of the corporate entity, the way that Frontier Logistics kept their books was sort of important to that argument. So why didn't you subpoena these records first? Mrs. Ligon, subpoena these records first.
I was not aware of the records, and while I heard that they were... Well,
surely
attached,
you must have realized that Frontier Logistics kept some financial records. I mean, it seemed like to me you'd want to see them to see if that bolstered your case in any way.
That is clear, and if it clarifies anything, I came on the case about a couple of years after it started, after the summary judgment had already been filed. I actually
so it's fair to say evidence. So it's fair to say it could have been requested. It just wasn't by prior counsel.
Correct. And to the extent it was requested by a subpoena, I maintain my argument. It should have been produced to everybody, but that is again a separate issue to your question. And generally, I wanted to touch on this discussion about a corporation or a business. What is in the will is not specifically a corporation, because we all know that someone can say, I operate something that's incorporated without it being a corporation. Otherwise,
In this case, as you responded to Judge Stafford, in this case, it happened to be a corporation.
yes, it did happen at one point to be a corporation. There's plenty of other cases out there where a corporation lapsed and then continued in existence with that name and was no longer a corporation. It's just a business at that point, and that's the argument with 32-301 or 3101 and construing a will based off the testator's intent at the time of death, is that at the time of his death, there was a business that was being operated as CSI, whether it was a division of FLS or whether it was just held out as CSI. There was still a business that was held out to exist. And going to Andrew v. Sprinkle, which was cited by Appellee, goodwill is a property interest that is transferable. However, that case in quotes states goodwill cannot be transferred apart from the business with which it is connected. So when you transfer the goodwill of the business, you're also transferring the business, which I get to in the brief on appeal, the appellant's brief, that the business of CSI was transferred and continued, regardless of what you call it. If you don't look to 32-3-101, and if you don't consider decedent's intent at the time of his death, and you just look back to when the will was made, then you can say, yes, CSI clearly had to be an incorporated entity to pass under the
Ms.
will.
Ligon still hold her 12.5% interest in Frontier Logistics?
It may have increased slightly, but yes,
Okay.
That's correct. And with that, I'll rest my argument.
Thank you very much. Mr. Hivner, would you do your job?
Yes, sir. This honorable court is now in recess until 11 a.m.
Thank you.
Your Honor.